Good afternoon or evening, everyone. Thank you for coming. Can I get everyone's attention? Thank you. Thank you again so much for coming to our second workshop, community workshop on our BPAS discussion that we've had. We had one in July. We've had a couple surveys, and so this will be our second one. We have an agenda on the tables in front of you. So we're going to talk about a couple of important topics tonight. We're going to talk about some takings issues. We're going to talk about infrastructure issues, and we're going to talk about the environment. The staff has done some great work on that, so I'm going to hand it over to them in a minute. I just want to, for those of you who weren't at the first one, who don't understand why we're here tonight or what the whole conversation is about, I just wanted to give a brief refresher on some of the topics from the first workshop. So again, this is the ROGO BPAS discussion. The main discussion is being led by the county, and we are doing a simultaneous discussion so that we can inform the Board of County Commissioners about our decisions as to what Islamorada wants to see for, if any at all, additional allocations for BPAS. BPAS, for those of you who don't know, sometimes I forget what room I'm in, is the building permit allocation system. That's the number of, the way we issue building permits in the village. Right now, we have 3 left to issue, and we have 54 people on the list. We've done a vacant parcel analysis, and we're still whittling that number down, but right now we're down to about 178 to 180 vacant parcels that potentially could need a permit as well. So those are some of the issues that we've been looking at. The Board of County Commissioners is expected to make their decision at their meeting in December, so we'd like to inform them or give a report to our village council in their October meeting, which would then inform them prior to their December meeting. Again, so far we've had one workshop in July, which some of you were there. I see some faces. We've had 2 surveys locally. The county, I think, has done about 4. We just finished our last survey last week, and at the end of the other presentations, I'm going to go over some of those results to give you an idea of what people are thinking around the village. And then the questions that we are looking to have answered is, do we want more allocations? If so, how many? And what would we want to use them for? Do we want all market rates? Do we want affordable? Do we want a mixture of both? Do we want to save some for takings? Do we want to just hand them out willy-nilly? Do we want to reserve them and use them sporadically? The considerations, again, were going to be infrastructure, the environment, potential takings claims, traffic. All of those things are the considerations that we're looking at. Again, we have 3 market rate allocations available. We have 300 early out evacuation available. We have 23 administrative relief available and 54 permits in the queue. The Village Council has also adopted 2 moratoriums at this time. They have a temporary moratorium on market rate allocations. That's set to expire in February of 2025. They have just recently adopted a moratorium on administrative relief applications, new administrative relief applications. That had passed the second reading and has gone to the state for approval. So we won't know when that expires until the state comes back with their approval of that. So that's kind of where we're at right now and what we're looking at doing. Our first presentation tonight is going to be by one of our village attorneys from Islamorada, Alicia Gonzalez. She had intended to be here tonight, but was unable to make it due to health reasons. So she's on Zoom, I hope, and ready to present her presentation. So I'm going to hand the presentation over to Alicia, if you're there, Alicia.
I'm here.
Okay, perfect.
Hopefully you all can see me. I do apologize for not being there. Jennifer was very discreet. I have COVID, so I didn't want to get anyone sick. What Jennifer explained to me is that one of the things that came up in the last workshop was the type of regulatory takings claims and potential Burt-Harris Act claims that the village could be facing due to some of the BPAS allocation issues. And so the objective of this presentation is to give everyone an overview of the type of claims that are usually brought along with regulatory takings claims, to kind of explain the basics of regulatory takings claim and also to explain the Burt-Harris Act, which kind of goes hand in hand with regulatory takings claims. It's a Florida statute that essentially codified a type of inverse condemnation in favor of property owners. So we'll go through a couple of those, and then to the extent that anyone has specific questions that are BPAS related, I'm happy to address those. So can you go to the next slide, please? Okay, so generally with, and just so that you all know, I probably should tell you that I'm qualified to do this. So I'm a land use litigator. I've been doing that for 15 years. And so I've seen it all. So, all right, the types of claims that usually come along with a new regulation or some kind of a denial of an application to develop property are usually what's known as inverse condemnation, which in the regulatory takings context. So not all inverse condemnation cases are regulatory takings, but all regulatory takings are an inverse condemnation claim. So the other thing is Burt-Harris Act, which, as I said, it's a Florida statute codified in 70.001. And essentially the legislature created a cause of action for cases that don't necessarily meet the threshold of an inverse condemnation claim, but it has its restrictions as well. So for Burt-Harris Act, it's when a new law or regulation interferes with an actual or potential use of the property such that the owner isn't able to achieve what they reasonably expected they could achieve and what they've invested in on the property, or such that the remaining uses are unreasonable. And I'll go a little bit more into that. I know that was a mouthful. So the other thing is substantive due process. That usually comes hand in hand. It's not really the focus of this presentation, but just so that you understand, or you all understand, there's a certain, these are like the top 5 claims. They usually all come together because when someone's trying to challenge a regulation or something that was done against their property, they want to make sure that they cover the full spectrum of what their rights could be. And in substantive due process, essentially what the property owner is saying is that they're questioning whether the law that restricts their property serves a legitimate government purpose and whether the governing body has a rational basis for believing that the law will forward that purpose. And it's usually a really low bar, and we're not usually concerned about substantive due process claims because they're relatively easy to meet the threshold. And I'm sorry if you hear toddler noises in the background. My 2-year-old also has COVID and has been home, so excuse that if you hear it. So procedural due process, whether a property owner was given proper notice and opportunity to be heard before their property was regulated. And then equal protection is another claim that usually comes hand in hand. Those are very difficult to prove. Usually the property owner claims that they were singled out and regulated different from what the other property owners have been regulated, but they have to show that they are exactly like other property owners that have been treated differently. So again, substantive due process, procedural due process, and equal protection are not necessarily the focus of this presentation, but just as a general overview, it's a good thing to understand that they come hand in hand with inverse claims and Burt-Harris Act claims. All right, next slide. So regulatory takings 101. These are the very basic things that you should understand about regulatory takings claims if you want to understand anything. So I put here that there's 2 types of claims, and really I want to qualify that with there's 2 types of claims that we would be concerned with, because there's a 3rd type of regulatory taking claim that is not relevant to the BPAS discussion. So the 2 types of claims that we are concerned with are facial/total takings, which is when the property owner says, this law upon enactment automatically affects the taking of my property. And it has to be a total taking of the property, meaning it deprives the landowner of all economically beneficial use. Very few claims for regulatory takings will be successful as a total taking because the bar is so high. It has to be a law that absolutely eliminates economically beneficial uses or value from the property. And as far as the lingo, it can be referred to as a total taking, a per se taking, or a Lucas taking. And the reason it's called a Lucas taking is because that's the U.S. Supreme Court's seminal case that defined what a total taking is. Now, the second type of taking, which is much more typical and probably what you would see in the context of BPAS, is an as-applied taking, which is when a particular law, when applied to a particular property, affects a taking of that property. And so it's called a partial taking, not because you're only taking a part of the property, but because it doesn't necessarily eliminate all economically beneficial use, but it takes a lot of value from the property such that even though it's not all economically beneficial use, it still might be interpreted as a taking. So the lingo is a partial taking. It's also known as a de facto taking because you have to consider the facts to understand if it is a taking. And then a Penn Central taking. And the reason it's called Penn Central taking is because that is the seminal US Supreme Court case that defined as applied takings as we know them today. Okay, next slide. So for as applied partial takings, these are the harder ones to understand because like I said, the Lucas takings are very straightforward. It's a law is enacted and it completely eliminates all economically beneficial use of my property. They're very difficult to show. As applied partial takings are a little bit like more subtle. So in Penn Central, which was that seminal case that defined an as applied partial taking, they said that there's 3 factors that a court has to balance to determine if an as applied / partial taking has taken place. And that's the economic impact of the regulation. And it has to be severe. Usually it has to be kind of like in the realm of a 90% reduction, 90% plus reduction in value of the property for this to be a substantial factor to weigh in favor of the property owner. Reasonable investment-backed expectations is the second balancing factor. And this is an important one. A lot of cases turn on this factor. And you see this a lot in the case law, even though the other factors, yes, it's a balancing test. There's 3 factors. A lot of courts put most of their weight on reasonable investment-backed expectations. And if you think about the reasoning behind it, it makes sense. A property owner, if they're being reasonable when they buy this property and they expect they can build a residential unit, and then for some reason that's taken away from them, then it's something that we can see as a society that potentially we might think should be compensable under takings law. And so one thing that's considered in reasonable investment-backed expectations is the owner's awareness of existing regulations when they purchased the property. So before they came to this property, was it a wetland? Was it highly regulated? And with a lot of the keys, the answer is going to be yes. The second factor under reasonable investment-backed expectations is whether the particular impacted property is highly regulated. So this is, again, whether it's a wetland, whether there's levels of regulation, which, again, you see in the keys. And if you look at a lot of the case law that has developed in the keys for takings, this is a big discussion, obviously, because starting in the 1970s, the keys started to become more and more regulated. And now we've come to a point where, you know, for even hurricane evacuation reasons, the development in the keys has to be really limited. So anyone who comes to a property in the keys at this point, especially, would be well aware that it is a highly regulated property and has to take the property with that known risk. And then the final thing is the character of the governmental action. Now, the case law on this is, again, very fuzzy. Like, there's a lot of things that can be considered with this factor, but the main thing is one property owner being singled out to bear the burden that should be borne by the public at large? So if there's all these developed properties and then you see one single property that hasn't been able to develop, and they've almost been singled out, and they're like, no, now your property is critical to our hurricane evacuation or whatever the case may be, then it almost seems like, you know, why should that one person be singled out to bear that burden? And again, this is just one of 3 factors, and all 3 have to weigh in favor of a finding for the property owner. And there's no hard line. And I know that's probably frustrating, but what I like to tell people is that usually, especially, well, maybe because I've been doing this for so long, when you see a case and you hear all about it, you can usually have a good sense just based on fairness of how this might come out in a takings context. Okay, and then as I noted before, most regulatory takings claims will fall under this category. So if you can go to the next slide. So we've covered inverse condemnation / regulatory takings, and then let's talk about the Burt-Harris Act. So the Burt-Harris Act, I believe it was enacted in around 1995. It's changed a bit since its enactment. The legislature has gone kind of refining it based on how the case law has developed. And essentially the purpose is to provide relief when a new law, so it has to be new, it can't be something that's in existence. And that's, it's a little fuzzy, but it's a good rule of thumb to understand that it does have to be a new law, rule, ordinance, or regulation as applied. So in Burt-Harris Acts, you actually have to apply the law to the property. It's not just upon enactment, although the legislature has gone back and kind of refined that as well. So there are some instances when just enacting the law could potentially trigger Burt-Harris Act liability. So the law has to be inordinately burden an existing use or a vested right to a specific use of real property. And that has its own definition, which we'll go through in the bullet points. So what's an existing use or a vested right to a use in a property as defined by the Burt-Harris Act? So existing use is either an actual present use or a reasonably foreseeable future use. And if this is starting to sound kind of like the balancing test for Penn Central as applied taking, that's intentional. I think the legislature was trying to reflect inverse condemnation case law, but also make it a little bit easier to prove under the Burt-Harris Act. And I'll explain why it's easier to prove. And so you could either prove one or the other. And then vested right means that the government has acted either in bad faith or there's some kind of equitable estoppel argument. Meaning, for example, if a property owner goes to get a permit, it's granted, they start investing money in actually developing the property. And then all of a sudden the government says, oh, no, we're going to pull that permit for X, Y, or Z reason. That could be deemed a vested right to develop the property because the property owner, in reliance on what the government did, started spending money. And so those situations are few and far between. We're usually looking at an existing use of property, which is an actual present use or a reasonably foreseeable future use. And then the use has to be inordinately burdened, which means it interferes with reasonable investment-backed expectations. It doesn't say reasonable there, but the law says reasonable. And again, you're kind of hearing the same terminology that's used in Penn Central takings, and I think that's with reason. It could leave an unreasonable remaining use of the property. In other words, a use that doesn't make any sense on that particular property. For as far as inordinate burdens, they can't be temporary. They have to be permanent, although there are exceptions to that, but I'm not going to get into it because it's way too nuanced for this presentation. In determining inordinate burden, consideration can be given to the time elapsed between when the law was enacted and its first application to the subject property. The law, the Burt-Harris Act literally says this, but it doesn't really explain how that should be considered or if it weighs in favor of the property owner or the government. I assume, based on how it's written, that it would weigh in favor of the government. If a law is enacted and the property owner just kind of sits on their rights and does nothing with the property, then their property rights kind of go dwindling. Okay, next slide. So why Burt-Harris Act claims often don't succeed? So Burt-Harris Act claims, in a sense, they were created to lessen the burden on property owners of proving an inverse claim. But in practice, what I've seen is that they're very difficult claims to make, mostly because of the pre-suit requirements, to be honest. Most property owners will not meet the threshold of making a proper pre-suit notice, and the appraisal requirements are pretty specific. And if they don't check every single box, they usually get kicked out of court. And I've seen it happen on so many cases that I've started to tell people, this is not the easiest thing to do, and you really have to, look at those claims on the front end. So the other thing is the government is given an opportunity to make an offer to the property owner before a property owner can actually sue under the Burt-Harris Act. So they have to give the government notice that they want to sue, and pretty much the exact basis upon which they're basing their suit, and how much they think their property value has been diminished by virtue of the government action. And then the government can take a number of steps to make a settlement offer to the property owner. So this is another reason why I think Burt-Harris Act claims usually don't come to fruition, because to the extent that they meet those pre-suit requirements and they actually have a colorable claim, the government, usually tries to make peace with the property owner, so to speak, and offer them something that, gives them back some value to their property, or something that they could do with the property that they're happy enough that they don't file suit. So it's a good law in the sense that it does give a good opportunity to both the government and the property owner to kind of have these pre-suit negotiations before people start spending a lot of money on litigation. And it's also not applicable to laws predating 1995, and that's because it was enacted in 1995, so the legislature did not make it retroactive to claims that precede 1995. So for all these reasons, it's kind of hard to make a Burt-Harris Act claim, but when they are made properly, it could expose government to a lot of liability. Okay, next slide. So the purpose of the Burt-Harris Act, as I said before, it's an extension of takings law, and it specifically states in the law it's a cause of action for governmental actions that may not rise to the level of a taking under the state constitution or the United States Constitution. And the reason why it creates almost an easier route for a property owner that might want to articulate a claim is because if you take one use from a property owner, like for example, the classic Burt-Harris Act claim that I've seen is where a government reduces the number of stories that an individual can build on their property, right? And like that's a very clear reduction in property value, maybe not significant, but some owners do go after that kind of thing. And so if the owner had a reasonable investment-backed expectation, they're no longer able to meet that reasonable investment-backed expectation, they could get compensation for that loss of that particular use. Whereas in inverse condemnation claims, you almost have to show that all property value is reduced in such a way that it's almost equivalent to a classic taking where government comes in and actively takes your property. And so in that sense, Burt-Harris Act is intended to give property owners recourse where inverse condemnation might not. But like I said, because the claims are so hard to make, we really haven't, or I haven't seen what the law can really do, because the way the cases have developed, it's been very kind of prohibitive for property owners to get through the courtroom door and actually be able to assert their claim in a way that's successful. And the Burt-Harris Act specifies that it's not necessarily appropriate to use takings law to interpret it. So even though we heard a lot of the terminology that's used in takings law in the actual Burt-Harris Act itself, we have to take that with a grain of salt, because we've already seen instances where appellate courts have deviated from what traditional takings law says about these terms in interpreting the Burt-Harris Act. So next slide. So just as kind of a summary, and this includes something that we didn't cover, but I'll go through it very quickly. So we've got Lucas takings, Penn Central takings, and Burt-Harris Act claims. These are the kind of regulatory takings claims that you generally see in the BPAS context. And so we didn't cover ripeness. Ripeness is what has the property owner done everything that they need to do to make sure that they can even go through those courtroom doors, okay? And for Lucas takings, a claim becomes right when the law is enacted, because the impact is so severe and so clear that you don't have to do anything else. As soon as the law is enacted, you know that it applies to your property. You can go ahead and make your claim. As far as Penn Central takings, they're called as-applied takings for a reason. The law has to actually be applied to the property, which usually requires that at least one application be made to develop the property. And it has to be not just any application, it has to be like a real application to develop the property based on the rights that the property owner has at that point in time. Sorry, my baby's crying. And in Penn Central takings, there's no exhaustion requirement, but the property owner does have to give the government reasonable opportunity to grant them relief. For Burt Harris Act claim, like I said, there are instances where an application has to be filed. There's two ways of doing it. Either an application has to be filed, or after a law is enacted, if the government sends out a notice saying to all property owners, this law was enacted, the impacts of the law are clear, you have a year to make your claim under the Burt Harris Act, then the property owners are free to go into court. But so there are two ways of doing it with Burt Harris Act claims. As far as pre-suit notices, they're only required under the Burt Harris Act claims, so you don't get the same type of opportunity for pre-suit settlement for Lucas takings or Penn Central takings. Although for Penn Central takings, it's arguable, right? Because if a property owner has to file an application, at some point, governments are able to see, okay, this is bubbling up to a point where it's probably going to result in a takings claim. So it's always good for staff to have their ears perched to that. So the test, I'm not going to go through it again, but it just lays out the differences. So again, Lucas taking all economically beneficial use. Penn Central, you balance the three factors. And then Burt Harris Act has three of its own factors to prove a claim. As far as temporary impacts, for Lucas takings, it is possible to prove a temporary impact if all economically beneficial use of the property was deprived for a period of time. And I'm not going to get into the specifics, but it's only retrospective. So if a government enacts a law, it deprives a property of all economically beneficial use. And for example, during the course of litigation, the government backtracks on the law and says, you know what, we don't want this law anymore. It's no good. Then the property owner can get compensation for the period of time in which all economically beneficial use was deprived from their property. As far as temporary impact claims for Penn Central takings, if it's not clear cut and retrospective like a Lucas taking, then you have to balance the factors again. And then Burt Harris Act claim, you don't get compensation for temporary actions, but there are some exceptions, which again are too nuanced to get into for this presentation. Opportunity to settle before suit, generally no for Lucas takings, generally yes for Penn Central because an application has to be filed. And then for Burt Harris Act claims, definitely yes, because there's a pre-suit notice requirement. And finally, as far as damages, for Lucas taking, the property owner is going to claim all the value of their property before the regulation that they're claiming impacted their property was enacted. For a Penn Central taking, you use a before and after test. What was the property worth before the regulation was enacted? What is it worth after? That's generally speaking. There are other ways of doing it, but that's the most common way. And so the difference between those two numbers is what the property owner will be compensated for. And then finally, for Burt Harris Act claims, it's going to be the loss in value due to the inordinate burden. So again, in the example where you've got a property that can build 20 stories and all of a sudden they can only build 8, they're probably going to claim that difference in value between a property that can build 20 stories and a property that can only build 8. And that could be a significant value depending on, where they are. Okay, and I think that's the end of the presentation. Does anyone have questions?
Okay, so, yep, we'll get you.
Ms. Gonzalez, I'm Van Cadenhead, and I'd like to ask you if you could give us a ballpark figure knowing how many appreciable lots are available here in Islamorada and the success rate of the takings cases that you have seen and the standard that's being in the state now for settling those cases. And if we can use our 300 assigned affordable housing units of permits to assuage the landowners and give them some partial value for that, how is that going to help us? And what's the percentage of success of the suits against the governments? given the convoluted process it has to go through for the property owner, but also for the taxpayer that has to pay on the other end of the legal action. Could you give us an idea, just in percentage, of how many are successful?
So if I gave you a specific percentage, I'd be lying because I haven't done that kind of analysis of cases. I could tell you what I've seen, okay? And very, very few takings claims in the Keys in particular have been successful that I've seen. But remember, what I'm seeing is appellate cases. So there are cases that a decision has been made, a court of appeals takes it, either affirms or overturns the case. And then often what happens is they're thrown back to the trial court. And it could be that they settle in the trial court, or that something else happens that's favorable to the property owner and not that favorable to the government. And I'm only seeing the appellate court decision that might have been favorable to the government. So it's hard to really say with any certainty how many of them are successful. On appeal, generally speaking, what we've seen, especially with the cases that come out of the Keys, the governments have been very successful in making a lot of these arguments about, like, for example, reasonable investment-backed expectations. If someone purchased recently, they can't say that they didn't know what was coming down the pipeline, especially because the Keys are so heavily regulated. But in the Keys, there's also a lot of properties that have been owned by a family since the 1950s, and so there may be a different analysis for those properties. So I can't give you a percentage because that I'd just be lying, to be honest. But as far as the question that you had about using the affordable housing BPAS to retain some value in the properties, that's a great alternative for the Village in particular, because you have a lot of BPAS allocations for affordable housing, and it's something that's very needed in this state. And so it's arguable that giving BPAS for affordable housing, it might not be exactly what the property owner wants, but they would be getting some value back to their property. Now, that takes care of inverse condemnation. It will likely take care of inverse condemnation liability, especially under Lucas, right? Because Lucas, you have to eliminate all economically beneficial use. So once they have those BPAS, it's very hard to make that argument. Likely under Penn Central as well, because as I mentioned, it has to, between the reasonable investment-backed expectations prong and the economic impact, which has to be really severe to be able to assert a successful Penn Central claim, it's likely that if you grant affordable housing BPAS, that would be a way to avoid takings liability under Penn Central as well. Now, where you might find some trouble is under the Burt-Harris Act, because under the Burt-Harris Act, they may say, well, we had a reasonable investment-backed expectation for for market rate housing. And so giving them affordable housing doesn't necessarily take care of the issue of interfering with reasonable investment-backed expectations. And it might, and I don't, I'm not saying that as a blanket rule, because there are no blanket rules when it comes to land use. Like, every case has to be taken on its own merits. And again, it may play into the Burt-Harris Act claim that, when they took, when they purchased the property, how long they've had the property, have they known that the Keys is increasingly becoming regulated? When did they actually invest in the property? That's another big question. So generally speaking, reasonable investment-backed expectations, they start as of the date of purchase. But for a property, for example, that's been held since the 1950s, the date of purchase is really not going to have a lot of significance with respect to reasonable investment-backed expectations. The question is probably going to turn more into, how much money have you really put into saying you were going to do this thing that you claimed you could do? So I think the affordable housing BPAS are a definite plus and are a good way of curtailing a lot of this potential exposure from the regulations on residential development. And then as far as you were asking also about some estimate based on the number of developable lots of potential exposure. And, you know, I hate to be this person because I'm going to frustrate you now. It's impossible to say without taking each and every property on its own facts how successful they might be at making a claim under, you know, an inverse condemnation action or a Burt-Harris Act claim. So it's really difficult to say just as a blanket rule. But like I mentioned when I was talking about, you know, Penn Central takings, Lucas takings, generally speaking, Lucas takings are very difficult to make. They are not usually going to be successful, just in general, not in the Keys in particular. With Penn Central takings, anyone who is coming in the Keys to make a Penn Central takings claim is going to have a high bar to jump over because again, as far as reasonable investment-backed expectations, this is an area that has increasingly become very regulated, and for good reason, because and it's not that, you know, government is necessarily singling out any one particular person. It's just as development goes along, you know, obviously, like if you've only got one road in and one road out, it's going to become more restrictive. And so, you know, I think up to this point, those arguments, like, okay, well, this person just kind of sat on their rights, did not develop their property. They saw what was happening. They saw what was coming, and they kind of just sat on their rights. And now they want compensation as if they should be able to develop. That hasn't been explored to its full extent, but I have a feeling that it's going to be a defense to any Penn Central takings claim that is made and any Burt-Harris Act claim that is made, to be honest. Hopefully that gives you some clarity, although I know it's not the best answer.
He said thank you.
Okay.
Thank you, Alicia. Thank you for all this information. We really appreciate that. My name is Don Horton, and I had a couple of questions. So you had said that the Burt-Harris Act, or something that you had shared with us, was not applicable to laws that predate 1995. And of course, the village inherited the county's ROGO system, and ROGO started on June 10th of 1992. So how does that come to play when you've got a Burt-Harris claim and the fact that since June 10th, at least since June 10th of 1992, if not even back when we were declared an area of state critical concern, how is that going to affect those type of claims, since I guess everybody that was paying attention would have known that there was a limited number of permits that were going to be made available, and they were going to be issued, you know, quarterly, and that eventually someday that, you know, that would run out. And I also had another question that you had brought up when you said most of your cases that you've seen were availed themselves in appellate court. So does that mean that there are a lot of cases out there that were settled between the government and the claimant, and so we don't even maybe necessarily know about that because of non-disclosure agreements or something like that? And I guess then the last one, to piggyback on the affordable housing, wouldn't there still be a claim on a reasonable expectation, because an affordable house is limited to the amount that it can actually sell for, where I guess our median house value that I'm told in our last workshops was something like $1.2 million in Islamorada alone. So there's a extreme loss between the reasonable expectation for a single family house as there is an affordable house. Again, thank you for this presentation.
Of course. Oh my gosh, you guys have really good questions. I present in front of lawyers and land use planners all the time, and I haven't gotten these great questions before. So, so as far as the Burt-Harris Act not being applicable to laws that predate 1995, and then the village having basically adopted the county's ROGO standards, which have been around since 1992, I mean, I want you on my legal team. This is an amazing argument. Yes, we could make that argument. Now, I can tell you what the counterpart to that is, which is the property owner will likely say, yeah, but it's not the same exact law. And so it's not going to be a very strong defense. Honestly, I've made the argument in the past against Burt Harris Act claims that a law, even though it's evolved a little bit, it's either been adopted by another government entity or maybe it's slightly different than how it started, it still has the same impact and therefore still falls under this provision in the Burt Harris Act that bars any claims based on laws that predate 1995. So it's an excellent argument, and yeah, we would definitely assert it. So that addresses that. Okay, and then as far as your question about my comment that most cases that I've seen are cases that go up on appeal, and then that a lot of them are thrown back to the trial court, and we don't necessarily get to see the outcome because they're not reported decisions like appellate courts. I mean, you could technically go through the docket in local cases, but no one's into that type of masochism. So because and you were saying like we don't necessarily learn about them because of non-disclosure. So I will say this, I don't know what percentage of cases have settled. It is likely that the stronger cases, yes, do get settled, and that's why we never hear about them, because there's a saying in the law which is, bad facts make bad law. So generally speaking, if you've got a good attorney on your side and the facts aren't sounding too good for the government, they're going to say, let's try to do something for this property owner, because if the worst thing you could do is have it go up on appeal and then have a bad appellate decision against government's favor because of the equities in the case. So yeah, it's likely that we haven't heard about a lot of the cases that may have been on the stronger side and that just settled out of court. And I will say it's never because of a non-disclosure, because in Florida, we've got government in the Sunshine Laws, we've got Public Records Acts. So governments aren't allowed to enter into non-disclosures. So I'm sure if someone wanted to do the exercise, they could probably see in the keys, like just do a public records request to all the local governments and see how many of these cases they've settled. But the other thing to understand is that a lot of this does not necessarily happen in the context of litigation. Like I said, in a Penn Central takings claim, the partial takings, the ones where you balance the factors, the property owner first has to make an application. And what happens often is if a government sees the writing on the wall, they see what's coming down the pipe, they're like, this sounds like a takings claim. The property owner is not exactly being shy about saying, I'm going to sue you. A lot of times the type of administrative relief that is granted to these property owners to avoid takings liability is something that, would be impossible to even find out that it was done. But it might have been done just to avoid, the liability that might come from a stronger case that they see down the pipeline. So there's a lot of levels at which this could happen. And that's why it becomes so impossible to really understand like what the success rate is for the government, because it's almost like a false success rate in a sense. And then as far as the affordable housing, you asked if there could still be a claim based on reasonable investment-backed expectations. So let's just to go back. So there's two types of claims where reasonable investment-backed expectations come into play. The first one is an inverse condemnation claim under Penn Central factors, which is economic impact, reasonable investment-backed expectation, and the character of the government action. And the court will balance all three factors. And so in a Penn Central takings claim, the fact that the value is extremely diminished, even like from market rate housing to affordable housing, it's likely not going to be enough of an economic impact to be able to overcome or to be able to prove the taking. Because even though no one factor will decide a Penn Central taking, economic impact's another really big one because it has to be almost akin to the government coming in and literally taking your property to put a fire station on it. That's how severe the economic impact has to be. So it is unlikely, not impossible, but unlikely that a claim under Penn Central inverse taking will succeed just based on the fact that they didn't get to build market rate housing, they had to build affordable housing. So I'm pretty confident that it's a good defense in that type of claim. As far as Burt-Harris Act, that's a different equation, because with Burt-Harris Act, again, the legislature made it so that it was slightly easier to prove than an inverse condemnation claim. So you don't have to, if one use was taken away from you, you could potentially make a claim for that use. Now, there's a lot of different defenses in Burt-Harris Act claims, so it's not a certainty either, but there still could exist the possibility of a claim in that scenario, even if we were to give affordable housing units to an owner who was expecting to build market rate units. But the other thing to consider here, which is a kind of a bigger picture, non-lawyer opinion of mine, is that at some point, the property owner has to invest a lot of resources into making these types of claims. So at some point, it just doesn't become, it's not enticing enough to the property owner. If they're going to just get depending how significant the delta is between market rate housing and affordable housing units, it might not be worth the investment in legal fees that they are actually going to have to make in order to make the claim. Now, potentially, if they're successful, they could recoup those attorney's fees at the end of the case, but they still have to have a lot of capital to be able to fund that type of litigation. And as I said, Burt-Harris Act claims are very difficult to make. When I tell you my personal success rate, and I'm not bragging here, I'm just telling you, like, this is how difficult they are to make. I would say that 99.9% of the claims that I've helped to defend against on the government side have either gone away after we respond to the pre-suit notice, or they've been dismissed upon our first motion in court and then upheld on appeal. So the property owner just got kicked out of court. That's how hard they are to make. I mean, I don't think most people understand what the threshold is for a Burt-Harris Act claim, just on the pre-suit notice requirements alone. Now, if the property owner got a lawyer that knew what they were doing, that might be a different question, but that's what I've seen.
Thanks, Alicia. My name is Ty Harris. It's no secret that when the village incorporated, that a lot of properties, especially on the US 1 corridor, were downzoned. In many cases, delegated to a conservation zoning where they had rights before that. Now that we've seen the Shands v. City of Marathon case come out, and I know that they're asking for rehearing and they want the full panel to hear it. What's your take on how that's going to affect these people who were downzoned that now have large swaths of conservation land that had some viable uses before? Thank you.
So I'm going to give another frustrating answer here. Okay, so to the extent that they were downzoned when the village was incorporated, which was some time ago, probably the type of claim that they could have made would be a Lucas type takings claim, assuming that the entire property was downzoned. So, and in those instances, their claims would probably be time barred. But I guess what you were referring to is that now in Shands, they're trying to say that a Lucas taking could be an as-applied taking. Depending on how the appellate court comes out on that issue, they still might have a time bar on them, because I don't think that necessarily, I don't think it's going to be that broad of a sweeping decision that all Lucas takings are all of a sudden revived. I think probably on rehearing, it's going to be a super narrow decision if it still comes out in favor of the property owner. That's just my speculation, because otherwise it might be madness as far as like reviving these dead claims, essentially. And again, even if these folks are able to revive dead claims, I feel like it would be an uphill battle at this point for a number of factors, because it's likely not just the downzoning. What you get a lot in the keys is also a lot of different regulatory bodies that are putting in all these different regulations. And so we have to see when those came into play and, how that affects even the type of compensation that they can claim. So it's hard to say how it'll ultimately pan out, but I mean, hopefully the Shands decision, even if they don't change their minds on rehearing, will at least narrow it so that they're not essentially doing away with the statute of limitations altogether as we know it. So.
Hi, I'm Deb Gillis. On the previous commenter, on Don's comments, you were talking about how difficult it would be to find out how many properties have been settled prior to either going to court or in the lower courts at least. It seems to me in our case that's where we kind of need to know that kind of figure. Do you have a recommendation for an easy way of trying to find out a percentage of that, or besides just open every record and look at it?
Okay, so I'll say this. I don't know that that's going to give you the information you all want, okay? Because when we can find out how many properties have settled, what have been the various differences between the case, maybe even just by talking to people who have been around for a really long time, just, not in a very scientific way. Or we could, just do a massive public records request and analyze the data, which is not worth our time. And I'll tell you why. So every takings claim, and I'm not exaggerating when I say every single takings claim, is different. No matter how similarly situated you believe the properties to be, there are so many different factors that are going to play into whether someone can make the type of a type of takings claim. The only one that I would say is like on a Lucas taking, because they're so few and far between and the impacts are so readily apparent on those types of claims. Maybe those are the ones that you can say they're not that different. But again, I mean, the success rate on Lucas takings, at some point in, I think it was like in 2009, I might be making that data, but I know there was an article that was written by a lawyer who went through the exercise of trying to figure out how many successful Lucas claims there have been. And it was like in the 0.001%. That's how rare Lucas claims are. But so probably the main claims that you all are worried about are going to be Burt Harrisack claims and Penn Central takings claims. And in those claims, they are so fact specific that even if we were to go through the exercise of finding out, like, what are the success rates for property owners and in what circumstances, it probably wouldn't have any real application to the individual properties that are left and potentially developable in the village. I think, what might be a better exercise for the village is eventually, I guess who's on the BPAS list, so you might want to do an assessment of, what we're looking at as far as liability from those properties, because they're actively seeking to develop. And then, you might want to look at the remaining properties that could be developable if there's any inkling that someone might be looking to develop them anytime soon. But before it actually comes to fruition, it's almost like an exercise in frivolity to try to figure it out, because even what could happen is we could go through the exercise of looking at all these properties that are vacant and potentially developable, and all of a sudden a new buyer comes in and purchases it, and we don't have the same reasonable investment-backed expectations of a family that may have held it since the 1950s. So we're kind of spinning our wheels before any of this comes to fruition. What I can tell you is if the village staff is careful about, how they're looking at these claims and getting legal input, we can also be in a situation where we're curtailing as much liability as possible by just analyzing cases that we feel like are heating up to a point where it might result in some type of claim. So I think that's the best bet, as opposed to doing this general, survey of how many have been successful versus how many have not been successful, because again, they all just turn on their facts. I hope that was helpful.
I think she said thank you. Is there anybody else? I didn't see any other hands raised. Is there anybody else that has questions for Alicia at this time? Great. Thank you, Alicia, so much. I think that was really great information. I think everybody learned a lot, so thank you.
Thank you all.
I hope you feel better.
Okay. I'm feeling fine. It's my poor baby that she's not feeling well. All right, guys. Bye.
All right. So next up, we're going to have a couple presentations by some village staff. First, we're going to have Robert Mather, who's our village review engineer, talk a little bit about infrastructure and village infrastructure and where we're at. And then after him, we're going to have our senior environmental planner and village biologist, Daniel Parabach, talk about the environment. We're going to let them both talk, and then we'll do question and answers for both their presentations after that. So you might want to use your pens and stuff if you have specific questions to write them down so you don't forget, okay? So I'm going to introduce Rob.
All right. Good afternoon, everyone, and thank you for being in attendance for this workshop. My name is Rob Mather. I work for the village in the planning department as a review engineer. My whole goal of this presentation is to provide information pertaining to our infrastructure, mainly looking at the traffic and road conditions, potable water, the wastewater system, solid waste, and stormwater. And just keep in mind that we're looking at this with the intention of thinking about how we want to proceed with our input to Monroe County on our BPAS allocations. And again, as Jennifer just said, we're just going to ask at this time that you please note your questions, write them down, and hold them until Daniel and I are both done with our presentations in order to make this go smoothly. So next slide, please. Back one. Yep. Okay, so to understand why our traffic can be so severe, let's not delay in discussing some of the local background conditions. A good place to start is why do we experience traffic delays in Islamorada? Let me ask you guys a question. How many of you drove here tonight? Raise hands. How many of you took US 1? Thank you. All right, that's all the information. That's all we got. Okay, so to answer our question, we have a limited roadway network here in the Keys. US 1, aka Overseas Highway, is our main arterial roadway that connects the islands all the way from Miami-Dade County to Key West. We do have local roadways, but they're limited. You still have to travel US 1 if you want to get between the islands by car. Our geography also plays a role when it comes to traffic. As you guys know, Islamorada is in the northern portion of the Keys, which means that any vehicles traveling to any destination south of us must pass through us to get to their destination. That also means they have to return through us when they leave their destination. So we get double that traffic that they may down south. Also, our roadway transitions, as you guys very well know, from 4-lane divided roadway in Key Largo to a 2-lane undivided roadway as you enter Plantation Key from the north. This creates a bottleneck and requires drivers to slow down when there's periods of high usage. Other traffic generators that we have here in Islamorada are accidents. We have a lot of special events that generate traffic. We do have school zones here. We also have the Snake Creek drawbridge, and all of these kind of combine and cause delays. They slow down our traffic system. So in addition to all these factors, our pass-through traffic, the local tourism that we get, we do have some residential traffic, but projects can also contribute to these delays. I want you guys to keep that in mind. So let's look at some of the future projects that are going to be going on. FDOT is going to be resurfacing Plantation Key, the roadway along Plantation Key. That's expected to start in roughly 2 years, around 2026. They're also they're doing a study right now, it's in planning and development, on replacing the Snake Creek Bridge. They're going to be doing a much larger bridge. I believe they're getting rid of the drawbridge portion of it and making it so that boats can pass under without having to raise a bridge and impact traffic. FKA also has some projects going on. As you guys have seen, they've completed the Islamorada Upper Matacumbe transmission main project. They completed that in July 29th of 2024. They're moving through Winley Key right now. That's what you can see in the photo there. And that's expected completion. I have January 2025 there. I believe it may be done sooner, within the next couple months. After that, they'll continue through Snake Creek. They do a directional bore underground, and I'll get into why they do that. And then after Snake Creek, they're going to work their way up through Plantation Key, and that may start as early as next year. So next slide, please. Oh, sorry. Thank you, Frank. So now that we have an understanding of our local traffic conditions, let's drive home how our traffic levels are evaluated. Monroe County has a consultant that conducts the US 1 arterial travel time and delay study on a biennial basis to monitor the level of service on US 1. This study gets conducted in peak season by completing 14 round trips in March from Key West to Dade and vice versa, and they actually measure the time and delays for each of the trip segments. The resulting study is a summary of the level of service for US 1, and it gets further broken down by each segment of roadway. For overall US 1, they score the roadway by comparing the average travel speed of the runs to an average speed of 45 miles per hour. Roadway segments are individually scored by comparing the average travel speed in relation to the posted speed limit for each of the segments. You can see the level of service rankings here. So for example, if your average traffic flow is 1.5 miles per hour above the speed limit, we know that segment is free flowing and it's operating at an LOSA. As you decrease your average travel speed, that's when we start to enter traffic. Usually level C, LOSC is kind of where we have that limit of operability. Anything beyond that, you see real bad traffic impacts. So in the 2021 study, US 1 was ranked at LOSC for overall US 1 all the way through Monroe County. And then to break it down into individual segments, Plantation Key was ranked at a C, Winley Key was ranked at a D, Upper Mat was ranked at an E, T-Table Key was ranked at an A, and Lower Mat was ranked at a C. In 2023, there was a draft study that was conducted, but the results were not approved by the county. They chose to gather additional data because there were excessive traffic signal and construction delays and the potential for improved traffic flow conditions. There was potential for improved traffic flow conditions following an FDOT signal improvement project. However, when March rolled around to conduct the study, BOCC motioned to delay the collection because the signal timing project had not yet been completed. So the next study is going to take place in 2025. In the draft study, though, I wanted to note the results. US 1 overall dropped from a C to a D, Plantation Key dropped from a C to a D, Winley Key dropped from a D to an E, Upper Mat remained an E, T-Table dropped from A to B, and Lower Mat actually improved from C to B. Let's see if I can do this. Perfect. All right, guys, let's transition, or should I say transmission, to potable water. Our water supply is serviced and maintained by the Florida Keys Aqueduct Authority, FKAA. Water is treated at the Florida City Water Treatment Plant and pumped through a 130-mile-long transmission main at a maximum pressure of 250 psi. As you can see in this graphic, our primary water source is the Biscayne Aquifer, which is located just west of Florida City. And there's a secondary aquifer, the Floridan Aquifer, which is treated by reverse osmosis that supplements the Biscayne Aquifer. Water use from the Biscayne is regulated at 17.79 million gallons per day during regular conditions and 17 million gallons per day during drought conditions. In conditions that require excess demand, they pull from the Floridan Aquifer system, and that has a capacity of 6 million gallons per day. FKA also has 2 reverse osmosis plants in the Keys. One is in Marathon, and that can supply 1 million gallons per day, and one is in Stock Island that supplies 2 million gallons per day. FKA is also working to increase the capacity of those plants to 4 million gallons per day. And as you may have seen in Islamorada, we touched on it earlier, but FKAA is replacing the 1980s water main pipes with larger and more resilient pipes. These new pipes are cathodically protected from saltwater degradation, and they're being routed deep underground at bridge crossings, further protecting our infrastructure from wind and storm surge damage. FKAA also has storage tank facilities and pump stations throughout the Keys so that they can ensure continual service to us. For example, they also have emergency backup pumps and 45,000 gallons of fuel in storage. One of the examples I was going to talk about was after Hurricane Andrew, they actually ran those pumps for 28 days straight to make sure that we had continuous water supply. All right, moving on. Now that we know the supply, can I get the next slide, please? Thank you. So now that we know the supply, let's look at what demands we have here in the Keys. The first table provides a listing of functional population projections, average daily demand in gallons, and the average per capita water consumption in gallons from the years 2000 to 2023. As shown by the table, there have been periods of fluctuation where the water demand varied, but generally remained under 18 million gallons per day until 2019. In turn, 2019 was the first year that we went over 18 million gallons per day, and we've remained there ever since. The chart on the right shows the more recent time frame from 2013 to 2023. We've seen incremental increases in the average water demand over the last 5 years, and our demand is currently for 2023 at 20.26 million gallons per day. So FKAA continually monitors and tracks these conditions, and they do plan for future changes that are necessary to continue supplying the Keys with an adequate water supply. Between the aquifers and the reverse osmosis plants and their proposed improvements, there is currently reserve capacity available that will satisfy our water demands. And just as a fun fact, they do have over $250 million in spending lined up for the next 5 years for improvements. Next slide, please. All right, let's discuss the water that does not taste good, wastewater. In the past, many homes utilized septic plants with drain fields, and businesses used outdated packaged treatment plants. These sanitary systems were prone to neglect and leaks, and they also contributed to our water quality issues. So in 2010, the state of Florida issued a legislative mandate that improved the wastewater treatment and disposal standards. This led to Islamorada tackling a $130 million septic to sewer conversion program between the years of 2012 to 2016. Upon completion, we now maintain a centralized vacuum and low pressure wastewater system to collect all of our wastewater. What gets collected in the pipes gets subsequently sent up to Key Largo through a low-pressure force main. We have an interlocal agreement with the Key Largo Wastewater Treatment District, and they provide our treatment. As you can see in this graph here, our monthly wastewater flows remain well under the allocated flows allowed by Key Largo. So one of the challenges with wastewater that we face is continual maintenance. Like any system, parts are prone to breaking and leaking. However, we have a hardworking team who tries to anticipate these problems, and they're always ready to respond quickly to our issues. One of the projects that we currently have planned is a booster pump station in North Plantation Key. And if this gets installed, the booster is anticipated to reduce wear and tear on the system by providing a more uniform flow through our pipes, eliminating hammering and air issues encountered with the pipe and pump systems. I've also spoken with AJ Engelmeyer, he's our Director of Public Works, regarding his take on our future capacity of the system. He believes that it's operating well and within our design capacity. The original design was created with a factor of safety built in that would account for future developments. But to add to that, our wastewater engineers, Wade Trim, are going to be conducting a capacity study over the next year or so to evaluate our future needs and anticipate improvements before they become an issue. Next slide, please. Okay, let's not waste any time transitioning to this discussion on solid waste. Island Disposal has been our solid waste hauler since January 1st, 2024. And I got the chance to speak with their operations manager, Jonathan Lindback, about the current and future capacity of our solid waste and any issues they may be anticipating. He told me that they have a relatively seamless transition from the previous hauler, and they were able to keep most of their staff that knew the routes. They also are more efficient with their use of automated arms on the trucks. And one of the good things that we have going for us here is we don't actually store our waste in Islamorada, or else we'd have a massive landfill, and that would be a capacity issue. But the waste that we do have gets hauled out to either Layton Landfill or Card Sound, and then hauled out of the Keys. Our garbage is transported to the Solid Waste Authority of West Palm Beach Renewable Energy Facility. And as far as the future capacity of Island Disposal, Jonathan told me that they're confident in their ability to continue servicing Islamorada regardless of the amount of development that we have take place. He felt that they could easily accommodate any extra routes with minimal changes. Next slide, please. Okay, we're almost done. I hope this presentation has not been too draining. The last topic focuses on stormwater around the village. We do not maintain a centralized stormwater system due to our unique geography and topography. However, we do regulate and inspect all stormwater management for any new development. For this purpose of providing safe management and disposal of runoff from developed areas and to protect natural resources to minimize or eliminate potential adverse impacts to surface waters, shallow groundwater, and other natural resource areas in the village. One of our more exciting developments is going to be the upcoming stormwater management plan. We're working with an engineering firm now to finalize our scope of work for the new master plan. This plan will be created to analyze and address the following topics, looking at water quality, current and future flood risks, redevelopment, and growth. So all very relevant to the conversations that we're having today. The new plan is going to be guiding our stormwater management program for the next 10 or more years, including analyzing or refining our stormwater-related policies and providing capital improvements plan for stormwater projects on a 10-year time frame with projects recommended by priority and cost-to-benefit ratio. These projects will focus on reducing runoff rates, increasing stormwater runoff, increasing storage volumes, and reducing pollutants. There will also be financial and funding recommendations to assist with these projects. Based on the final project and cost considerations, the funding sources may include grants, public-private partnerships, bonding, and loan funds. Next slide, please. And that's it. Just note down your questions if you have any for me, and we will respond to them after Daniel goes. Thank you, guys.
Good evening, everybody. I know most everybody here, but if I haven't met you, my name is Daniel Perbach. I'm the Senior Environmental Planner and the Village's Biologist. And before I start my presentation, let's all give Rob another round of applause. That was his first presentation in public since he started with the Village, and I think he knocked it out of the park. Okay, so I'm gonna talk tonight a little bit about the environment. This is gonna be a very broad overview, trying to get everybody on the same page. My goal is to try to give you some more information to facilitate a good discussion and how the environment affects BPAS, and kind of get everybody together. And let's go. All right, Frank, you might have to help me out. Next slide. Uh-oh. There we go. All right, so to start off, we're just going to talk about the kinds of habitats we have here in Islamorada. I'm going to break it up into upland and wetland. So for our types of upland habitat, we start with the hammock, which is going to be the kind of areas that have more trees, that might look more forested. Some of them could be sparser than others. Some of it could be impenetrable forest. We rank them in terms of qualities from low, moderate to high. The high quality being the most protected, and the low quality being a little bit lesser protected. We also have beach berm habitat. A lot of times beach berm, especially in the village, it's not just a sand dune, it's actually covered in specific types of vegetation, and these are really important resiliency features that help protect from storm surge and flooding. And then you have disturbed with habitats. So these are habitats that may in the past have been cleared or have some sort of development on them or have been impacted maybe by a storm. And you can have disturbed with these other types of habitat on the same property. And then the least environmentally sensitive is going to be your scarified. So this is going to be land that has been cleared. It may not have any trees. It may have trees, but it doesn't contain any sort of like protected habitat or ecosystem. Next slide. So then we have our wetland habitats. We have the mangrove wetlands, which can be part of a mangrove fringe. They can be inland from the tide line. They can be isolated. They can be in freshwater. These are also important habitats as they protect from storm surge. And then we have salt marsh buttonwood wetlands. A lot of times these are going to be just upland from the mangrove wetlands, and they act in the same capacity as to shield from some storm damage. They can also be freshwater or saltwater, and a lot of times you'll see these paired with the mangrove wetlands, not just by themselves. And then we have the disturbed with salt marsh buttonwoods, and a lot of times you get these after a storm, or in the case of this photo, illegally disturbed. So next slide. So that kind of gets us on board with what habitats we have. We had a study done a couple years ago by a consultant to kind of look at the changes in the village from pre-development till present. The pre-development, in this case, being pre-Flagler Railroad. They didn't take into account like Calusa development or anything like that. So these numbers look pretty drastic, but just know it's basically from the beginning of all development up until 2022 when the study was done. Next slide. So as part of that study, they gave us some pretty cool graphics. We'll start north and work our way south. So this is Plantation Key. The purple is hammock and the green is mangrove coverage. And you can see the pre-development versus 2022 when the study was done. I got the numbers here. So out of the 4 islands, Plantation Key has lost the greatest square footage of hammock in the village. It lost approximately 76% of the hammock and 42% of the mangrove coverage. Next slide. So Winley Key lost 50% of the hammock, but gained 58% mangrove coverage. You can see kind of what I call the horns of Winley Key that have expanded in mangrove coverage. This is just a natural succession. And from people that I've talked to about 20, 30 years ago, that south side of Snake Creek used to be a pretty good bonefish spot, but now it's mangroves. So next slide. Upper Mat lost the largest percentage of hammock, not necessarily square footage. It's lost 82% of the hammock, and it also gained 26% of mangrove coverage, and that's mostly on that north end. And then also actually a little bit too on the south by Little Basin. Next. And Lower Mat. So Lower Mat lost 76% of the hammock and 63% of its mangroves. There's not much hammock left on Lower Mat. There's only a few remnant patches. And as you can see, obviously all of Port Antigua, Safety Harbor, all that used to be mangroves before it was dredged, filled, and developed. So that's kind of where those numbers came from. Next. So now we kind of saw the environment, how it's changed, and so how does that affect the BPAS in our conversation? So applications for residential developments that have to go through the BPAS system, they get scored on a whole bunch of different factors. The one obviously that I focus on is the environment. And currently, as the BPAS scoring is that the current system disincentivizes development in sensitive habitats, sensitive areas near endangered species, and like you can see here that the more protected or sensitive the habitat is, the more disincentivized it is to develop in terms of your score. So if you're developing on a high quality hammock or a beach berm or salt marsh, you get a -10 for the habitat protection category. And conversely, it incentivizes developing scarified, disturbed lots that don't have any sensitive habitat. And in this case, you actually get a +1 point, which is the only positive point you get in all the environmental sections for developing. And then there's a section for threatened endangered species. You can see the scores there. And then if it's in with the Florida Forever acquisition area for critical habitat, it gets a -10. So the system as it is right now, just is if you guys want to have part of the conversation, that the current BPAS system disincentivizes development in sensitive areas and incentivizes in lesser sensitive areas. Next slide. So that brings us to what are our current protections? So these are some examples of our current code and some of the environmental type regulations that are protecting some of the environment. So we have limit clearing. If you have hammock, there's different ratios that you're allowed to clear. It ranges from 50% of low quality all the way down to only 10% if you have high quality. We require conservation easements for developing on hammock properties. Wetlands are very protected in the village. All development is prohibited on red flag or undisturbed wetlands, and you're only allowed to develop 10% on disturbed wetlands. We protect seagrass and corals if you're building a dock, seawall, anything like that. There's a lot of restrictions on how you can design that stuff and to avoid hard bottom and corals and seagrass. As everybody knows, we're deep in sea turtle nesting season, so there's lighting restrictions and setback requirements to provide the sea turtles nesting area. We have a tree replacement and mitigation ordinance, so if you remove a tree, the tree has to be replaced somewhere in the village or restore habitat. And then we also require open space. So no matter what in the village, if you develop a lot, you have to have a minimum percentage of 20% open space, and that can be as much as 90% a lot as open space if you're developing in some protected areas. Next slide. So, like I said, this is to more get the conversation rolling, kind of get everybody on the same page. So this presentation is more to kind of get you thinking about that. Do you want to see changes? Do you like the way the scoring is? Do you think it's too restrictive? Just some things to think about. Next slide. And then just get involved. This is why everybody's here, right? So you guys are doing a good job at being here. Other ways you can get involved, though, we do have the comprehensive plan update that's going to be coming up in the very near future. So if the public wants to get involved with that, the comp plan guides all of our ordinances and how the village moves forward with development. And that's a really important process that's going to be happening, so you can get involved with that. You can meet with staff at the office. You can meet with council members. Let us know your opinion, how you feel. We're happy to meet with anybody. And the online surveys that we've been sending around, those are pretty informative. We just got the results back, and I think Jennifer's going to go over those tonight. So that's some ways you can get involved. And that's it. Short and sweet.
Great. All right, so Daniel, why don't you and Rob stay up there and we'll ask questions. Before we get to questions, I saw a lot of people taking pictures of the slides and rushing through. I just wanted to let everybody, I should have said this at the beginning, all these presentations are going to get posted to our website. I'll try to do it tomorrow. I have a busy day tomorrow, but by Friday at the latest, they'll all be posted to the planning department's website. So if you missed a slide or you wanted specific information about any of Daniel's habitat information or Rob's infrastructure presentation or even Alicia's takings, they'll all be posted to our website later by the end of the week. So you'll have access to all that. So questions? Yes, Fan.
This one's for Rob, and it has to do with water, our water supply. And you mentioned the sources that we use. Those aquifers are subject to a lot more draining now because of all the South Florida City construction that's going on. And they have like 8,000 affordable housing units going in right behind the Last Chance Bar. And if you go from Florida City to downtown Miami, both sides of the road are construction that's either underway or just beginning to fill up now. And all that water is coming out of where we're getting our water from. And if we get into a situation where we start using brackish water that has to be reverse osmosis before we can drink it and use it, then that's pretty much the end of the Keys. And I really am against asking for any more BPAS for that reason alone. And not to mention just the traffic. And you mentioned, as far as traffic, T-table. And I was not aware, when you say T-table, are you referring to the Indian Key fills? Or because there's only a little single lane road that goes out to T-table, and I don't think there was any traffic problem there ever.
No, it's just the US 1 portion along the fills there.
Okay, along the fills. Okay, well that's also a very dangerous place. I mean, many people have gotten into wrecks and people have died there, and so that's a bottleneck that we have to examine when we examine the pressure of traffic. And I just would like to thank you for bringing the water situation up, because if we lose the water, if we overdevelop and lose the water, and they need more in Key West and they need more in Marathon, and you mentioned their desal plants. Their desal plants, when they're working at full capacity, only bring up 10% of the water that Key West needs a day. And if they double it, it'll be 20%. And they haven't gotten Marathon online yet to really produce. So if we all of a sudden start getting brackish water through our pipeline, we're cooked. And that's nothing else we can do about it or say about it. So I would, anything we can do to restrict development, further development in the Keys, and put more people on that pipeline and more users on that pipeline, I think the better off we are. And the same goes for, thank you, Mr. Mather. This one goes to Daniel. You saw how much, with your charts that you just showed us, how much we have lost in vegetation from over the years with the development. We have so little vegetation left, and the vegetation is essential for the wildlife that people come to the Keys for. In other words, we don't have any habitat for birds. They're always cutting down trees. I fought for a Royal Poinciana and a Sapodilla to no avail, and was told that they were invasive exotics. Well, they're not invasive exotics. They're habitat. And we can also use our habitat funds. Like we're on Windley Key, we have a landscaping project that's going to begin after the pipeline is in there. And that whole strip could be a strip hammock. We could make a hammock out of the Windley Key median. And for the sake of the path, and create hammock and create big trees, bring big trees in there, so the whole thing would be shaded. I hope those kinds of projects continue, and the permits to cut down trees and scarify property and build more houses at the cost of losing our environment is considered by whoever sits on the council benches. Thank you.
Don had his hand up first, sorry.
Awesome. Thank you, Jennifer. Thank y'all both for a good presentation. Rob, I'm glad to know that you inherited your dad's sense of humor. So I think it's partly because of me that your dad ended up in the fire service. We worked together to have their volunteer fire department. And all you remind me of him, you did inherit his sense of humor. I got a couple of questions. have you thought about, as we go through our new regulations, maybe giving some kind of permit bonus for people that may put in pervious pavers instead of pouring concrete driveways and those kind of things? I think that maybe there'd be a incentive for people to start putting in pervious pavers so that we have less impervious areas in driveways, backyards, and those kind of things. So it's just maybe a suggestion on that. I won't pontificate as long as some, but is there a different criteria used in the Keys versus Miami? Because, you know, we see this level of service on our roads. You try to drive down Kendall Drive in the busy part of the day, and from one end to the other, they're well below their posted speed limit. And, you know, they don't seem to be affected the way that we get affected. So, yeah, we get a little bit perturbed when we're put behind 15 minutes driving north to south. They're in gridlock. So I just wonder if they use a different. And I know you're not a traffic engineer, but maybe in your studies, in your discussions, you might have heard about that. And as far as our infrastructure goes, it seemed to me that you indicated, or that you inferred during your presentation, that we haven't maxed out either of our infrastructure when it comes to potable water or wastewater. We're under what was projected, and we're trying to stay ahead of that problem. So that's what it sounded to me, and is that what I heard from you saying?
Okay. Great questions, thank you. So we'll start with the last one. All the data that I've seen in research that I've found has shown that we are not yet at that critical level for potable water, according to FKAA. They track the demands, and they show that their aquifers and their desal plants, with those, they still have adequate supply. So we're not quite there yet. They do have $256 million in spending to do to continually improve. So we're just not there yet. As far as the wastewater system, same thing. In the graph, we're still under our permitted allocated amount by Key Largo Water Treatment District. But as far as capacity goes, I mean, that's really a great question to bring up to our engineers and have them think about over the next year as they do our evaluation of our system. All that information should be in their reports and findings. As far as your other questions, the first one being stormwater, looking at awarding some type of bonus points for doing pervious solutions. I know other counties do, they factor in green retention, bioswales, any type of water catchments that goes toward improving water quality and lessening the runoff quantity. Right now, I would say that our regulations, if you were to do pervious pavers, we would require you to capture less stormwater on site, just because you are reducing that overall impervious area. But as far as like the BPAS system goes, I'm not sure that there are points or anything awarded for that type of infrastructure, but that is a very good idea. And then as far as the criteria on evaluations of other roadways outside of Monroe County, I don't know specifically what Kendall or Miami-Dade or any of them do. I do know that it's likely different. I know Monroe County is unique. They do have an assessment, an evaluation methodology that they created just for Monroe County to evaluate our roadways, because we cannot be evaluated in the same way, seeing as we only have one arterial roadway. So in other areas, they may refer to the highway capacity manual, and they may evaluate based on that. So that's all I got without saying specifics.
Hi, Deb Gillis. So in speaking of traffic and the study, and I've known this over the years, but you kind of brought it home tonight, is it's amazing that it's based off of the speed limit, and our speed limit is 45, but when we do 45, we only get a C. And yet, if we move the traffic faster above speed limit, which is not legal, technically, you get a ticket, but we get an A for that. So there's something wrong in that that terminology. Now, I'm not suggesting that we should raise or lower the speed limit. It just doesn't register right to have that happen. So maybe you could pass that along, or you have a comment of how all that came about.
Sure.
And then I have a second question more about environment. You, Daniel, you presented data from when the railroad was put in, so we'll say 35 to now. Is there any studies that have been done since? Because I believe that we actually got very serious, or much more serious, about keeping environment, 12 years ago? Maybe 15 years ago? And that we've done a much better job, but between the railroad and that time, we didn't do a very good job, and we will all admit that. But is there any studies that are more current than the one you presented?
So as far as your question, comment on traffic, so what I believe you're talking about is for overall US 1 and their ranking of C for 45 miles per hour, correct?
Well, we have it here by sections they do it also.
Yeah.
Yes, the 45 miles per hour, yes.
Okay, yeah, so they adopted 45 miles per hour as the average speed along US 1. So, I mean, we know there are areas along US 1 that the speed limit's 55. We know there are areas where the speed limit may be lower, higher, but they tend to take the average. And yes, in some areas, you can't classify, going over the speed limit. It wouldn't make sense, like you said, but for all of US 1, that's what they're looking at, and then they're averaging that speed, and that's the determination that they made. So basically with an LOSA, what they're assuming is that when you get on the road, you have that ability to go over that speed limit. It doesn't necessarily mean that you have to, but that's what they're testing for, so that you're not restricted by the car in front of you. You would be able to go over the speed limit. And then as far as individual segments, they base those off the speed in relation to the posted speed limit. So yes, there are certain segments where they say if you're 1.5 miles per hour over the 35 mile per hour speed limit, we know there's unrestricted flow of traffic. But if you're 6 miles per hour under, maybe you're at LOSC or LOSD, and you're likely being limited by the cars that are in front of you. So hopefully that answers.
So several years ago, there was a conversation that if we raised the speed limit, like on the fills, because at the time the fills was a problem, that it improves our LOS, which, because it would match what is flowing down it. There just seems to be a flaw, and I don't know how you correct that, because we all know that there's a traffic problem, but the way they rate us and in the way they use that figure towards whether or not there's additional development or not development is crazy too. I mean, so I just wanted to bring up that point. I don't think there's a real answer to it.
Yeah, good point.
And then the other question?
So as part of the report that we got that I showed the figures for, I'll double check. I don't think it made it in, but we did request that. I thought it would be best to know from 86 to present what that change was, because that's when all the environmental protections in the county went in, and we've done a better job since 86. I will dig through that report and see if I can find it, and we'll get it out to you guys. I don't think it made it in, though. But that is really good information that I think we should have moving forward, especially with BPAS. So thank you.
Hi, my name's Larry Dalton. I'm a resident of Islamorada. I've got a question for you, Rob, and it has to do with the traffic information. One of the things I think that we have to look at as we're looking for BPAS and we're talking about development is evacuation times for the entire county in case of a storm is really what we're looking at. The studies are being done, you said in peak season. Do you know what month? March. They're being done in March. Well, okay, we're not having a lot of hurricanes in March. We're not having a lot of evacuation in March. How are they extrapolating the data to September 10th or September 11th, which is peak hurricane? and looking at those numbers, what is the calculation that is being done to make that determination?
Great question. Thank you. So just for this purpose, I want you guys to think of these studies as separate. So the one that you brought up, the hurricane evacuation modeling, that's separate from the US 1 arterial time and travel delay study. So the hurricane evacuation study, that's just taking into account your speed limits, your number of residents, and how fast they can get out. That's not taking into account, timed runs through the Keys. That's purely, to my knowledge, looking at speed limits and the ability for people to get out and looking at the queuing as they get out of the Keys. So as far as the other, does that answer your question? You're talking apples and oranges. Right, yeah, the two studies are unrelated in a way. They both pertain to our traffic, but they're analyzing different things.
This is a bit of a stretch, but so I moved here in 1960. Have taught marine biology from 1972 through most of my career. And it's been extremely difficult to watch what's happened environmentally over the years. And one of the problems that I see us having is that we tend to try to prevent further environmental damage or maintain what we have instead of being more proactive and seeing if we can turn the tide. What we're doing right now with coral restoration is one of the huge things. Seagrass restoration is phenomenal and vital. Mangrove protection, you guys know that we bought, 150 some odd acres of mangrove community there in the north end of Islamorada to protect that so that nothing could happen to it. And literally, I don't think anybody will ever be able to do anything to that. And that was for one purpose, and that was to protect the mangroves, the nurseries, and the island in the event of a hurricane. One of my recent suggestions that I've talked to several of you about has been the idea of eliminating the fills, T-table fills. And the reason that I suggest that is because prior to the railroad, the water flow through there was just steady. 14 feet of fill was put in, dredged in from the bay and from the ocean side. And then when the 35 hurricane hit, it blew all of that fill, it was mainly silt, over into what is now the flats in front of Indian Key. Prior to that, there was open water access. Then if you look at the sailboats and all of the traffic that was taking place in and around Indian Key, very healthy water flow. My contention is that a lot of the problems we're having with the Florida Bay relates to the fact that we don't have any water flow through that area. By eliminating the fills, putting a causeway there, a bridgeway to allow the water to flow would restore the water flow to where it was pre-railroad. And I believe the temperatures in the Florida Bay would be reduced. I believe that the restoration to the corals we have back there, as well as the seagrass, would be restored. We'd eliminate some of the problems we have with the temperatures, with the algae blooms that we're having. And I think that you go to Channel 2 and beyond and look at the water quality there, both on the bay and the ocean. So I think it's something that I know DOT now has the field, but I really believe we need to lean into that. And I don't know if you guys have any comment about that kind of out-of-the-box thought.
That's a great idea, and I think it deserves some modeling and studying, and see if DOT has an appetite. Maybe next meeting we'll toss it out, or you can make a phone call to D6. I'm sure they'd love it. So it's an awesome idea.
First of all, thanks, gentlemen, for everything. My name is Mark Mancini. I had two questions for Rob. First question, it just was curiosity. Why Lower Mat improved while everyone else didn't? That was the first question. The second question is, with the time studies with the speed, was that just averaged throughout the week? Did they not separate Friday evening to Sunday versus Monday through Friday afternoon, where obviously the weekend's going to be more impactful for people going further south, and that would be a judgment as to how much is staying here and how much is going south of us and staying there for the weekend or longer. So, thank you.
So two great questions. First, I'll touch on the timing of studies. So they do 14 round trips, 7 from each end, 7 starting at Miami-Dade County line, working down, round trip back, and 7 starting at Key West, going up and back. And when they do these in March, they do them over a 2-week period. So they're hitting all of the days, and they randomize the times. I personally don't have information or access to the data on what times they go up and down the Keys. I would like to imagine that it's reasonable times for commuters, but I don't have that information for you. And then as far as why did Lower Matt improve? Again, it could have just been the year of the study. I mean, and it could be after 2021, there was an influx. I wasn't here back then, but everyone was recovering from COVID. Maybe tourism was opening back up, so they could have had a really busy March. And 2023, just no delays through Lower Matt. I don't know.
Maybe fewer unmanned cop cars in Lower Matt, people were just I guess.
It could have been. It could have been anything. Not sure.
Thank you, gentlemen, for all your time. I have a question for Rob. On high tides in the past have put water on the old highway just south of Plantation by the Sea condo. It was evident that it was salt water because there hadn't been rain, and now there's every heavy rain like we've had, there's a big puddle there. So obviously that storm drain isn't draining out, but at times in the past it has drained in. So that water is going untreated right out to the ocean, correct?
I'm not familiar with the infrastructure that's there, but if we're getting king tides, there is a possibility that the outlet is at a higher water level than the inlet, and water naturally goes from high to low. So any water from the outlet could be coming in, and vice versa. It's a possibility.
So that should be something that we definitely need to look at, because you don't want all of that water that came in with the rainwater to be draining out untreated out into the ocean.
Definitely noted. And, part of what our consultants are going to be doing with our stormwater master plan, they're going to be recommending these projects in our worst areas like that. They are also looking at tidal flooding, high tides, things like that. Just any ways that we can improve our stormwater infrastructure and looking for improvements to make it better down here. I mean, that's what the whole study is going to be about.
And a question for Daniel. So how was the pre-development estimate attained? Obviously, there wasn't anybody around now that was around then. And when you look at the pictures of Henry Flagler's Railroad, you see so much scrub. You don't see the hammocks that we have today.
I'd have to double check the methodology section in that report, but they state how they got their original measurements. I'm sure it's a combination of historical documentation, whatever the earliest USDA pictures and surveys were done, soil surveys, and then when aircraft were invented, they did flyovers of every county. So they used some of those old historical aerials from the original USDA flyovers. I'm not 100% sure that I covered all their sources, but it was a compilation of all that data.
Thank you. I have one comment just regarding BPAS and vacant lots and building rights coming from other properties. So regarding vacant lots on the BPAS list, if a lot is on BPAS, it has already been reviewed and approved by a biologist, by the building and planning departments, correct? So would it make sense to allow a building right from a scarified lot to be transferred to a hammock lot? Obviously, the clearing for the hammock lot would be restricted as on their building application, but it would allow the transfer and then take that one hammock lot if it's not going to be, given a permit, but they obviously have an expectation of a permit to be taken off the list.
So are you asking if somebody has a building right on a scarified lot, could they do a TDR to a hammock lot, or are you asking vice versa? Yes. Scarified to hammock? No, unfortunately, currently our TDR code does not allow the go from one environmental habitat to the other. There's different classes, and you have to stay within your class when you do a TDR. So unfortunately, you couldn't do that. We are working on, and I know that's why Ty's raising his hand, we are working on an amendment to the code at the moment. I'm hoping to get that before the council before the end of the year. That would have some tweaks to that could potentially help with that situation. It hasn't fully been fleshed out yet, so I don't want to say exactly what it says, but there is a potential that by the end of the year that might be a possibility.
Maybe that would be something that a workshop, maybe that would be something that a workshop might be beneficial, to maybe flesh out some ideas like this that could be helpful.
Thank you. Anyone else have questions for Daniel or Rob at this time? Great. All right, I've got like a little bit more to do, but we put some food out, so I don't know if anybody wants to take a quick break and grab something to eat before I get back up there and start talking again, or if you want to listen to me, that's up to you guys, whatever you want to do. You can also eat while I talk, so if you want to take a few minutes and stretch and grab some food, I'll talk again in like 5 minutes or so. It's your imagination 5 minutes.
Try to put a little humor in the presentation and soften them up a little bit.
The first night's deciding whether or not you want to run for council or.
I know they're really trying to capture the stretch it out there. And I didn't think this is good, but I need to know 86. September 86 until now. Like that's what's in there. And so they wanted to come on. And they kind of showed us some data. Like, I don't know, never made it into the because the report, yeah, it's a draft. Right, so since we're in an area of state concern, we have to do that hurricane evacuation modeling. That's everyone out there, 24 hours a year. So when they're doing that study, they're looking at population of people that are permanent residents that are leaving. They're also looking at like mobile homes, tourists, other so that study, they're all those people. I think I'm bringing in some data and see how fast they would be able to evacuate if they can make it out within that. So I know you didn't present that right. Shouldn't it be part of this conversation? And then you so I was out of town. So that's I looked through that when I was making my presentation. There was information on it.
It's just unreadable. It's unreadable. Yeah. It's just maybe if you. I don't know. It's something. It's that's what it's something. Maybe you go on your computer. Yeah. It's so small. Oh, okay. This might be. That might be it. Yeah, that might be better. I just don't know which one is this one. Yeah, but go on your computer because I know what you mean. But yeah. It's just on here. See how. Yeah, I know what you're saying, but go on your BPAS quarter. Let me try this. And then we can see the latest date. You might be able to figure it out. Maybe this one. Quarter 3. Yeah, 2024. Here we are. That would be the latest one. We're in 2024.
So we're going to give you about 2 more minutes to break, and then we're going to come back. Frank, are we ready? All right, if everybody could come back. You can eat while I talk. I'm not offended by that at all. So I'm going to get into our last survey that we did and some of the results. But first, I just want to thank everybody so much for participating and taking time out of your, I'm sure, very busy schedules and your evening and spending a couple hours with us here to have these conversations. It's very, very important for all of us and staff to hear your feedback and hear your viewpoints. It's critical for the future of Islamorada that we have these conversations and that we move forward in a positive direction as a community. So I'm pleased at the turnout, and I want to continue to have more of these conversations as we move forward. So thank you very much for your participation. So we did 2 surveys, like I said. The first survey we did early on was more of a demographic survey that talked about who is going to possibly be participating and answering surveys and that kind of information. The second survey that we just ran from August 1st to August 15th, just ended last week, was a more of an in-depth survey about some more questions about BPAS itself. So the survey was for Islamorada residents only. It had, the first question was, are you an Islamorada resident? And if you checked no, you were said, thanks for trying, but See you later. So we had 368 Islamorada residents respond. We had others that tried to respond, but 368 were valid responses. And I have to take my glasses off, sorry. 83 to 94% response rate for each question. So that means some people skipped some of the questions. There was a total of 7 questions. And some of the topics were, do we want more allocations? How many units do we want? If we accept more, how should we use them? And what are our primary concerns with getting more allocations? And we had specific questions about 24-hour hurricane evacuation. Did I make it work or did I? Oh, there we go. Okay. So this is just sort of general results. I'm not going to go through each one of the questions. We're still sort of dialing in on some of those results, but I wanted to give sort of a general overview of what we are seeing so far. Is do we want more allocations and how many units that we want? The most popular answer based on survey questions was none at 36%. However, when you take the rest of the majority at 63.3%, they were in favor of some allocations rather than none. It was just broken up in like how many or what kind. So 63.3% were in favor of some allocations and 36.6% were in favor of none. 66.9% would rather use additional BPAS allocations from the state to handle potential takings liabilities over taxpayer money to handle takings liabilities. So we have that. If we accept more allocations, how should we use them? The highest support would be to grant allocations to a combo of market rate, affordable, and workforce housing. So it was pretty clear. I don't have the percentage on that, but it was pretty clear on the survey that everybody wanted a combination. Nobody said all market rate, all affordable. Everybody pretty much across the board said, let's do a mixture of everything. And then, what are your primary concerns with getting allocations? And I think it's clear from our conversation this evening that that tracks, right? Traffic impacts, number 1 concern. Environmental impacts, number 2 concern. And then we go into financial impacts to tax bill due to liability, infrastructure impacts. Interestingly enough, the 24-hour hurricane evacuation ranked around 10%. Only about 10% were concerned about leaving the Keys in a hurricane within 24 hours. But then when asked directly about the concern over the ability to maintain the 24-hour hurricane evacuation, 76.2% of the respondents were very or somewhat concerned, compared to the 10% that ranked it as one of their not primary concerns. So it's very interesting responses that we're trying to dig through, and I just thought it would be interesting to share some of those responses with you. So we're still looking at all of those. I know that our agenda talks about doing some roundtable discussions. It's 7:30 and getting kind of late. I'm happy to stay here as long as you want, but I figure you all have more important things to do, and we have plenty of, have had a lot of discussion tonight. We are going to be accepting comments in writing through September 13th via email. My cards are on the table over there. I can be found, you can also find me online. I'm happy to accept any written comments tonight. If you want to stay, jot down some comments on the cards, on the pads of paper in front of you. If you want to send me an email later, if you want to give me a call, set up a meeting, I'll meet with whoever, whenever. We want to hear from as many people as possible. This is not, a decision or any recommendation that's being made by one person or 2 people. It should be a community decision that we'd like to hear from as many people as possible. So I would like to also remind you that the presentations, again, are going to be posted hopefully by the end of the week. And again, thank you all for coming. You're welcome to stay as long as you want. I think we're going to skip the roundtables tonight, but if you're in here enjoying your food and you want to chat amongst each other about some of these topics and write down your comments, feel free to do that. And again, you have until September 13th to provide me written comments. So I'll take any additional questions if anybody has any final thoughts or questions before we wrap up. Anybody have anything they want to throw out there? Or if someone could just grab a mic for Alina, please.
So getting back to making these workshops more public with more involvement, more ability to ask questions. You had Alicia on Zoom today. You could have had Zoom for everybody.
So, yeah, I can address that. So it's been my decision not to provide Zoom for public participation, mostly because if you've been to our workshops previously, we do a lot of, we do some group work at the tables. It's difficult to do that on public participation on Zoom when you. It's not conducive to the type of workshops that a planner would run in a normal situation. Moving forward, if we do other types of workshops that are strictly presentations or other things, we can certainly talk about having Zoom participation. I think Deb has a question.
When you say you're going to put the presentations online, the actual people talking or just the slides?
The slides.
The slides.
Yeah, I'm not sure, Frank, is the video? Yeah, the video will be online as well. But the slides will be posted to the planning department. If you go to the planning department webpage, there's a side that says ongoing projects and BPAS discussion, and it'll be posted right there.
A question regarding some of the numbers you spoke about earlier. You talk about, I think it was 180 vacant parcels? Approximately. Does that include the 54 that are already in the BPAS line?
It does not, no.
It does not. So really, you've got 230.
Roughly.
Okay, or 240 lots that we're talking about.
Roughly.
Are any of these vacant parcels set up for multi-family residents or big enough for or are they all single lots?
So they're all single-family zoning, vacant or on the BPAS list, so probably vacant, but single-family zoning. The analysis we haven't completed yet are some may have other beneficial use, like if they're on Tavanero, the airstrip, you are allowed to build a accessory structure without a primary structure. You can build an airplane hangar. That has a beneficial use other than a single-family home. So we haven't discounted all of those yet because we're still weeding through some of that.
Thank you.
Actually, I had a couple of questions. One was, is there a map of these undeveloped lots at all?
No, we haven't put anything on a map yet because, again, we haven't finalized the list, so we don't want to put anything out there and scare people and say, why are you putting my lot on a map? Yeah, you know what I'm saying? We're trying to, weed that out. I'm hoping maybe by the end of the year we can have sort of a, quote, final list.
I'm just thinking about a neighbor of ours 2 doors down who had to transfer a permit over from property he had in the Bayside. It's a beautiful, large lot, beautiful views of Alligator Reef, oceanfront. And for him not to be able to develop that, to me, it just seems like a waste. It's just a disservice to him for that. I guess the other question I had too was actually more of a comment, not a question, sorry. I don't know how many decades ago they allocated the lots for here. And I understand things change over the years. But if there's a street, and let's just say they carved out 6 lots, they assumed they wanted 6 homes on there. Otherwise, they would have divided it into 3, made 3 homes. The way I look at it, I'm a newer resident than most people here, probably everyone here, is if that's what their design was all these years ago, I understand there's a permit issue and things change, but that was their intent. And to me, it's almost a disrespect if that was the whole idea. This is how we wanted everything done. And so that's why I think we should try to get as many BPAS permits as possible, because this is the way the city was designed and carved out. And I think based upon that, that's my rationale for getting more.
Yeah, and that's the kind of feedback that we need from not just you, from everybody, because other people like Van has indicated that he doesn't want us to have any permits. So we need to weigh both of those sort of feedbacks and make our recommendation to the council at their meeting in October. So that's the kind of feedback that we're looking for.
Jennifer, not that it matters other than, because I know you don't enforce deed restrictions, but Tavanero does not allow anyone just to build a hangar. You have to build a house with a hangar, so.
I can only speak for the
I understand
village.
that, but just for,
The village allows
just so
it.
everyone understands.
But the village allows
That
it.
can happen, yeah.
The village allows it.
First of all, thank you for putting this together and all the information. My question and an observation is on the survey. And I know you guys do a great job putting it out in the newspaper, and I got alerts on my phone and all that stuff. But if we have, in round numbers, 5,000 registered voters in Islamorada, and we get 300 and something people that respond, and 24 people here tonight, how do you draw a conclusion that 15% of the people want it several different ways, and is it the 85% that just don't care? I mean, how do you draw a conclusion based on those numbers?
I know. It's difficult to do, right? But I think we have to present those numbers to the council as well and say, that's why we ask you to sign in. That's why we track who responds to the survey, because we say, these are the people that attended. These are the numbers of people. This is the response that we got. These are the people that are interested. These are the people that have cared. So, if you have people that couldn't make it tonight but want to comment, that's why I'm saying give them my email, have them call me. I will take every comment I can up until, the reason I say September 13th, because at some point I have to cut it off so we can, and analyze the results. But, we will take as many comments as we can, because the more people, the better. To your point, we need, we have, 5,000 residents, we have 7,200, in the population. So, we need as many people as possible. So, yeah, I hear you.
And to follow up on that, actually, the question I had was, do we have a number of how many email addresses we have of the 5,000, number one? Number two, how many people clicked on the link, I'm sorry, who got the email? Do we have a tracking to see if they actually got the email and were able to go to the page or didn't go to the page or were undeliverable? Because if it's a matter of not having email addresses, there's solutions around that, such as with the tax bill, put in an email address line, then you'll get a higher percentage that way than just come to the website and sign up for.
Right, so we didn't set specifically, other than Judy Hull, which I really appreciate, she blasted it to her chamber membership. But we didn't, other than that, send it to specific email addresses. We put it on our website, we blasted it to our social media channels, we put it on our Islamorada app several times through the course of the survey. And we announced it at a couple council meetings. So we did the outreach that we were able to do. I don't know that we have email addresses for every person in the village. I think that would be a little cumbersome for us to try to email out to everybody, but we're always looking for ways to continue to reach people. So, that's something we can think about, and I'm happy to take any suggestions.
Jennifer, I'd like to clarify a point for our newcomer here, Mr. Mancini. One of the reasons that there were a lot of plats in 35 before there were any houses was because, it's hypothesis into the future, people want to build. And since then, we have bought the Glen property right there next to Venetian Shores, and that was all plotted. That should have all been another development just like Venetian Shores. That's what they had in mind. But things change. Things change, the environment changes, the amount of people change, the traffic flow changes, the TDC brings the rest of the world into our lap. And so we have a whole different range of processes that we have to follow just due to the fact that time marches on. And I would really like to see anybody that has an oceanfront property be able to develop a nice house on it. That'd be great for the environment, or great for the ad valorem of the village. And, if somebody's going to spend that much money to have a lot on the ocean, then he should be able to somehow or other get a permit to build some type of a house there. Maybe not a big mansion, but I think there's still room for redevelopment of the scarified properties that we have here that would accommodate a whole lot of growth. and accommodate a whole lot of construction and development, but it wouldn't be tearing down. I wouldn't want to see another tree go. That's my, it's been my mantra for years, because I've seen so much hammock go under the bulldozer, and every time there's a hurricane and people say, oh, well, the tree blew down in my yard, let's just cut down all the trees. And that's how we've lost just about all of our greenery and habitat for the animals. And the animals, the natural wildlife here in the Keys is one of the main reasons people come to the Keys, to see that, to enjoy this environment, and to be in a relaxed atmosphere. If you want to go to Miami Beach is right up the street. We don't want Miami Beach here. We don't want Miami Beach. We don't want Key Biscayne. We want to have the fishing village of Islamorada, the sport fishing capital of the world. That's what brings people here, and that's why people, pay big money to come here. And the people like me and Tony, who have been here our whole lives, we're blessed. We're lucky. We've seen it since it was primitive, and it was enjoyable, and it was paradise. But we hate to see it crushed under the tsunami of greed of people that want to continually make more and more concrete and less natural resources. So I hope Mr. Mancini understands my passion, and I understand his point of view. But I really think that in the long run, if you want your grandchildren to have a place to come to enjoy what the Keys is, then we have to put the brakes on what's happening now. Thank you.
Thank you. Anyone else? Final thoughts? Great. Thank you so much, everybody, again, for coming. I really appreciate it. Thank you. Don't forget to leave your comments or send them to me via email. Have a good night. Drive safe.